Welcome to The Explainer. Today, we're diving into a genuinely fascinating collision of history and modern law. We're going to look at how an intellectual property system designed centuries ago to protect inventors is completely clashing with today's deeply complex, interconnected technology. Let's kick things off with a pretty staggering number, 250,000. That massive figure is the estimated number of active patents covering a single modern smartphone. Think about that. From the specific battery chemistry all the way down to exactly how your fingers swipe across that glass screen, the whole thing is just a dense web of overlapping legal protections. Now, you might be wondering, what does 250,000 modern patents have to do with a 19th century physicist? Well, how did we get from a system meant to reward a solitary genius for a single breakthrough to a world where one device literally requires navigating hundreds of thousands of legal tripwires? Let's trace it back to its roots. Section 1. Lord Kelvin and the myth of the solitary genius. To really understand our modern system, we have to look back at William Thomson, who you probably know as Lord Kelvin. He was essentially the ultimate beneficiary of this classical system designed to reward that solitary genius. Take the siphon recorder, for example, which Kelvin patented back in 1870. This was a brilliant, highly tangible invention. It used a frictionless, electrified glass pen that continuously sprayed ink onto paper to record telegraph signals. Basically, it bypassed human operators, completely revolutionized communication speeds, and literally helped make the transatlantic cable a reliable commercial reality. And Kelvin didn't just theorize, right? He built things. In 1858, he patented the mirror galvanometer. By 1867, he'd created an inkjet capillary siphon and then automated it by 1870. Get this, he even patented a drip-resistant water tap in 1889, literally just because he was annoyed by a leaky faucet at his estate. He was an incredibly active historical solopreneur, rapidly commercializing his research into very discrete physical solutions. Section 2. Patenting the physical world. You see, in the 19th century, patents were inherently physical problem-solving tools geared toward direct commercialization. You found a physical problem, you built a unique machine to solve it, and the patent protected your specific, tangible manufactured good. Over his lifetime, Kelvin secured around 70 patents. We're talking 12 in electric telegraphy, 25 in marine navigation, and 29 in general electrical instrumentation. He amassed genuine wealth this way. He even bought a 126-ton yacht. He did it by systematically translating physical science into manufactured standards across multiple booming industries. For this kind of discrete invention, the system worked perfectly. But we have to ask, how does progress actually happen? There's this fantastic quote from Mark Twain. It's like a mental kaleidoscope. Every time you twist it, the exact same colored glass pieces form an entirely new, beautiful pattern. I love that because it hits the nail on the head regarding combinatorial creativity. The reality is that even great inventors, yes, even folks like Kelvin, are mostly rearranging existing knowledge rather than pulling entirely new ideas out of an absolute vacuum. Section 3. The patent thicket crisis. So what happens when you apply that rigid 19th century system meant for single physical inventions to our deeply cumulative, incredibly interconnected modern tech? Well, you don't get a protected market, you get a massive roadblock. Back in 2001, UC Berkeley economist Carl Shapiro defined what we call a patent thicket. He called it a dense web of overlapping intellectual property rights that a company must hack its way through in order to actually commercialize new technology. It's a perfect visual for the legal minefield that's currently suffocating innovators who really just want to bring their products to the public. The contrast here is just incredibly stark. We have completely shifted from the 19th century model, which was this amazing engine of commercialization driven by discrete physical breakthroughs, to a modern era defined by defensive moat strategies, evergreening, and overlapping shields. Today, unfortunately, patents are often less about actually making a new product and a lot more about preventing anyone else from making one. Section 4. Navigating the legal minefield. Surviving in this modern ecosystem brings severe financial and operational consequences. It's even given rise to entirely new business models, like non-practicing entities, often called patent trolls, who extract licensing fees purely through the threat of a lawsuit. Just to put this into perspective, think about the number $12.5 billion. Back in 2011, Google bought Motorola Mobility for exactly that amount. And they didn't do it to innovate. They did it strictly to acquire 17,000 patents to use as a defensive cross-licensing shield against lawsuits from competitors like Apple and Microsoft. It is literally a multi-billion-dollar battlefield. And if you look at the medical field, the strategies are arguably even more intense. The pharmaceutical company AbbVie filed an astonishing 247 patents on a single biologic drug, Humira. 247. Many of these were filed years after the drug was already on the market. It was a strategy built purely to act as an impenetrable fortress against cheaper generic competitors, effectively extending their monopoly for years. But what if you decide to just fight your way through these thickets in court? Well, the median cost is $5 million for a single U.S. patent infringement suit where more than $25 million is at risk. That's a ruinous financial drain. It acts as a massive barrier, especially for smaller inventors, and absolutely stifles actual viable research from ever reaching the market. Not surprisingly, all of this has sparked some massive regulatory battles right now. For instance, the USPTO recently proposed rule changes specifically targeting these thickets, focusing on something called terminal disclaimers. And almost immediately, there was incredibly strong political pushback, including a formal opposition letter from Americans for Tax Reform, or the ATR. Let's objectively break down both sides of this policy debate, because it's absolutely crucial. On one side, the USPTO proposes that if one claim in a terminal disclaimer is rejected, all tied patents become unenforceable. Their argument is that this clears out the thickets and promotes generic competition. But on the other side, the ATR argues that this exceeds the USPTO's authority. They say it unfairly penalizes inventors by invalidating entire portfolios over a single rejected claim, which disincentivizes the incredibly high-risk, high-cost investments required for medical innovation. It's a really complex tension between promoting market competition and protecting the massive investments needed to develop life-saving drugs. Section 5. Rethinking modern innovation. With our current system clearly struggling under the weight of these defensive tickets, we really have to ask ourselves, how might we redesign our systems to reflect how cumulative human progress actually works? History gives us some great alternatives here. Take 19th century metallurgy, for example. During the first industrial revolution in northern England, we saw rapid industrial advancement specifically through the free, collective sharing of optimal blast furnace designs. They figured out that cooperative innovation often yields better, faster technological leaps than locking every tiny incremental step behind a legal wall. Which brings us to our final takeaway for today. If progress is an ongoing human conversation, a collaborative, cumulative ecosystem born of shared knowledge, why does our system reward endless litigation? Just imagine how much faster we could cure diseases or build new technologies if we redesign these frameworks to reward true collaboration instead of legal roadblocks. It's a profound challenge for the future of innovation. Thanks so much for joining me on this explainer, and we'll see you next time.